Hello, I'm going to talk today about debt collection law in Colorado. This is an update to a talk that I gave a couple years ago. There have been some new developments. A little bit about me. Uh, this is a little bit about Colorado Legal Services, the program that I work for. It's a nonprofit providing basic legal services for free to two classes of clients. One, people with low incomes and own very few assets. And secondly, anybody 60 or older, regardless of income. The major areas of service for our program are family law, which would be divorce and child custody, that type of thing. Housing, which is covers evictions, issues between tenants and their landlords, issues between tenants and other tenants, and so forth. Public benefits is another major area and happens to be one where I spend a great deal of my time, which covers Medicaid issues, for example, Social Security issues, unemployment benefits, and so forth. And finally, the fourth major category, there are some others, but these are the major ones. The fourth is helping clients dealing with debt and debt collectors. And in this area, we primarily provide advice to people. So, what I hope to accomplish today is to provide some basic information about the subject of debt collection law in Colorado. Obviously, I can't provide advice, but if you think you may qualify for the services of CLS, there's a number of ways you can apply. You can apply online, you can call, and hopefully you will have this handout so you don't have to write all this stuff down or trying to remember it. Okay, so there are three basic kinds of debt. These are a little bit out of order. The middle one, unsecured debt, is the most common, and this is your typical credit card debt, medical debt, uh, rent pay owed to a former landlord, interpersonal debts. There's no specific asset associated with an unsecured loan. The second category, major category, is secured debt. Secured debts are secured by a asset. The prime example would be home mortgages, where the homeowner has to pay the mortgage or potentially, after some procedures which are quite involved, or possibly have the house sold to pay the debt. Car loans are another major area of secured debt. Finally, there's some special cases, including things like student loans, child support, unpaid taxes, fines, and penalties. These are subject to unique separate rules, and the rules that apply to secured and unsecured debt generally don't apply to those areas. So I get this question a lot from clients. What will happen if I don't pay my unsecured debt? By the way, this talk is from the standpoint of debtors. Our office represents debtors, people that owe money or are claimed to owe money. We don't provide service to creditors. There are other lawyers that do that, but we don't. So I get this question a lot. What happens if I don't pay my unsecured debt? If I don't pay my credit card debt, for example? Well, the first thing creditors will do, if they haven't already, by the time the person contacts us, is they'll call or they'll send nasty letters. Uh, Later, they may assign the debt to a debt collection company, and debt collection companies are companies or entities that are in the business of collecting someone else's debt. They are regulated by state and federal law, which I'll get into later. There are also companies out there that are debt management service providers or debt consolidation providers. And they're also subject to regulation, which I will get into later. So back to the normal process for an unsecured debt. If the letters and the calls don't provide any relief for the creditor, in some cases they may file suit. It doesn't happen in every case. The really diligent ones will first determine if it's worth their effort because it doesn't do any good to sue somebody that can't pay it back. Um, the creditor has to go to court and convince a judge that the money is owed and show the proof for that. And the debtor receives notice of this proceeding, so has the opportunity to appear and object, at least object to the amount if the debtor doesn't think it's correct. With some rare exceptions, which I'll mention later, creditors cannot simply self-help to collect their debts. They have to go through court. Finally, again, I get this question a lot. Can I go to jail for not paying my credit card debt? No, no, and no. That doesn't happen. Only in rare instances like unpaid child support, unpaid taxes, are people ever put in jail for not paying a debt. So, what happens if I don't pay my secured debt? Well, the same criteria or factors apply here that apply to the unsecured debt. In addition, the secured creditor may take steps to sell the secured asset in order to try and collect. So there are procedures in place in most cases that govern how a secured creditor can actually sell the asset to try and be paid back. The most complicated ones and the most time-consuming ones involve home mortgages. As you might expect, the rules are designed to try and keep people in their homes and to give homeowners every opportunity to salvage the house. There are some cases where there's no procedures. Vehicle repossessions are one. If you don't pay your car loan, they just show up in the middle of the night, maybe, and repossess the car. And then there's also, as I mentioned, some self-help options for some creditors. A bank, for example, that has loaned money to a customer, and the customer is required to keep an account at the bank. This is spelled out in the loan agreement, but if the customer doesn't pay the loan, the bank can simply take the money out of the account. Payday loans are another example. The borrower agrees in advance to permit the lender to take funds out of its account if the borrower doesn't pay. So what can I do? What should I do if I can't pay? Well, I always advise people, if the original creditor is still involved, the doctor's office or whatever, I advise people to talk to them and try and work something out. In the vast majority of cases, creditors do not want to pursue collection efforts. They'd rather just agree to some long-term payout or something else to try and collect their money. If the claim has been advised, it has been assigned to a debt collector, however, I do not advise our clients to talk to debt collectors. That's usually just not productive and stressful. However, there is one circumstance where I do advise them to talk to the debt collector, and that is where the client is able to scrape together a amount of money substantially less than what's claimed, but offer that lump sum payment to the debt collector and say, look, this is all I've got. This is all I can do. Take it or leave it. And oftentimes the debt collectors will accept that because they don't want to be in a long-term payout situation either. Their business is turning debts over, collecting quickly and moving on to the next debt. So they don't want to mess around with a long-term deal. Finally, debt management service providers can be helpful for debt consolidation type business, but beware of scams and high fees. And as I mentioned earlier, there are now some regulations in place limiting how they do their business. So, debt collectors, their actions are limited by state and federal law. Probably the most important one is they have to stop contacting a debtor if they receive written requests to stop. And we have found that letters to debt collectors requesting that they stop are very effective because there are some pretty severe financial penalties if the debt collector continues to contact the debtor after receiving a written request to stop. Debt collectors can't use specified threats or tactics. They can only contact a debtor during daytime hours in most cases, and they can't contact debtors at work except in some extreme cases. Okay, this is something new. There are now limits on major limits on efforts to collect medical debt. A couple years ago, the Colorado legislature determined that medical debt should be treated differently than other unsecured debt because generally people can't choose to incur medical debt. I mean, if you get sick and have to go to the hospital or go see a doctor, you have to do it. So the limits in place are, um, among others, are medical debt can no longer be included in a consumer's credit report or used in calculating a credit score unless the amount is very, very high. And I'll mention that in a minute. The interest rate on medical debt is 3%. Upon receiving a written request from the consumer, the debt collector must stop further efforts to collect medical debt until it first provides an itemized statement. The debt collector also has to stop efforts once it becomes aware that the consumer has filed a appeal with its health insurance company. There are restrictions on payment plans. There's restrictions on legal actions. There are provisions designed to mesh the Colorado law with federal law on surprise billing. So I mentioned the amount of medical debt that can be subject to can be used to impair a person's credit score, and it's based on an annual determination and by another federal agency of the unit value or the unit cost of one. I'm using it's a high number in 2000 the 2025 it's $806,500. So unless the person has medical debt in excess of that, it can't be used on the credit report. So there are three ways that debts can be collected. I mentioned self-help, which is limited, garnishment, and liens. I'm going to talk about garnishment first. There are two kinds. There are wage garnishment and account garnishment. Uh, Garnishment is commonly used for unsecured debt, credit card debt, whatever. Again, the creditor must first go to court and obtain a judgment stating that Steve Koerner owes so and so X amount of money before a garnishment can be started. And then the creditor goes back to the court and asks for writ of garnishment because Steve hasn't paid the judgment. Um, some income is exempt from garnishment. I'll mention that again. in a minute. So wage garnishment is limited by Colorado law, uh, and is based, the limitations are based on how often a person is paid. It changes every year with with an adjustment for inflation. In 2025, for example, a person paid weekly has to earn more than $592 a week and 592.40 in order to have any amount garnished. And that number is net of Social Security, required taxes, employer sponsored health insurance. So that's a net number. In addition, for most debts, only 20% of the person's disposable earnings, which is what I just described, gross earnings less these deductions, only 20% can be garnished. Higher percentages do apply to child support and taxes. Account garnishment, this is where, for example, a person has a bank account, a person who owes money has a bank account, and there's a judgment issued against the person for a debt. State law protects funds in bank accounts of the debtor across all accounts for a total of $2,500. There's something I caution clients about, and that is joint accounts. Joint accounts would be, for example, where daughter wants mom to be on her account or vice versa. So mom and daughter are jointly on the bank account. If however, if daughter doesn't pay her car loan, mom's assets in the account are at risk because her name's on, she's an owner of the account too. So I advise people to think carefully about that and generally avoid joint accounts. There's other ways of accomplishing what they want to do without adding a name to an account. I also caution people about mixing exempt and non-exempt funds. So we'll talk about this in a minute, but don't put your Social Security money in the same account with the money from earnings or gifts or lottery winnings or whatever. Child support is another similar area where the child support should go in a separate custodial account because the money belongs to the child, not to the parent. Caution for debtors. Even if the money in the account cannot be garnished because it's exempt or it's below the $2,500 limit, it can still be garnished if the person doesn't file an objection promptly with the court. Even though that wouldn't have happened if things had gone the way they were supposed to. Okay, liens on real property are a very complicated subject, and we're not going to have time to go into that today. But in general, a person who owes a debt ultimately and is ultimately sued, and the creditor obtains a judgment from the court. The judgment can be filed with the county real estate records anywhere that the person may own real property. And the filing of the judgment creates a lien on the property. So the title to the property now has an additional lien on it. And when the property is sold at whatever point, the lien will have to be paid if there's enough money generated by the sale. It's also possible for a lien holder to foreclose its lien through a court process. Again, I'm not going to go into that, but that can happen. It does happen in some cases. Exempt income and assets. Okay, so common types of exempt income: government benefits, retirement benefits, disability benefits. Exempt assets include houses up to a limit, vehicles, tools, and retirement accounts. So back to the houses, the current exemption level is $250,000 or $350,000 for seniors or disabled people. Vehicles, I think it's $15,000 for the total of all vehicles. But just be aware that there are some exemptions. They're not complete exemptions in most cases, but oftentimes they're enough to keep a creditor from trying to foreclose. Right. I mentioned the medical debt, bankruptcy. People often, our clients often say, "Oh my gosh, I need a bankruptcy. I have so much debt. Look at all this. There's no way I'm ever going to be able to pay this." And we stress to people, don't file bankruptcy unless you have something to protect, an income or a house, for example. There's no point in filing bankruptcy just to wipe out debts because if you once you file, you can't file again for 8 years for Chapter 7. I failed to mention there are two types of debts, two types of bankruptcies for individuals. There's a Chapter 7 liquidation, which is wipe out all the debt. And then there's a Chapter 13 wage earner plan where the debtor gets the creditors to agree to a long-term payout, usually 5, 7 years, to pay off the debts under some court supervision. And those are much more complicated bankruptcy cases, and the debtor does not receive a discharge until the plan is completed, as opposed to the liquidation, which once it's filed and over with, the debts are discharged. So again, we advise clients, it's a magic bullet. Don't use it until you really have to. Some helpful resources on this subject are found on the CLS website and the Federal Trade Commission website. And I hope this was helpful. Thank you for your attention.